Right now, on Law&Crime's special report, Justice and Peace. Last night, the Minneapolis Metro Council voted unanimously to ban no-knock warrants. The legislation is aptly called Brianna's Law.
Brianna, that's all she wanted to do was save lives. So with this law, she'll get to continue to do that.
Plus, Louisville's police department finally released the incident report in the death of Brianna Taylor. Shockingly, it's nearly blank.
It's a tremendous slap in the face to release something like this after 3 months that is so blatantly inaccurate.
Also, the use of inmate labor to fight fire in California is commonplace. The average inmate makes less than $5 per day to risk their life. Is this a form of modern-day slavery? Justice and Peace bringing you inside the movement from police reform. It's Friday, June 12th, 2020. Welcome back to another episode of Justice and Peace. I'm your host, Brian Buckmire. Let's start off with Brianna Taylor. We're seeing widespread reform and change, but yet we're not seeing any arrests. Let's start with the good news first. As we said last night, we heard that Brianna Taylor's law is kicking into effect, where no-knock warrants were suspended for a month and now are becoming illegal. The Mayor Fisher said yesterday that once that law hits his desk, he'll sign it. But let's first take a listen to the family as they reacted to this positive news about the law being changed.
I'm just going to say, Brianna, that's all she wanted to do was save lives. So with this law, she'll get to continue to do that. So we're grateful for that. She would be so happy.
All right, so I'm very excited today because we have with us Executive Director for Partners for Justice, Emily Galvin Almanza. I'm so glad I got that name right. I hope I did. Emily, thank you so much for being with us. I had an opportunity to look at your resume and speak with you beforehand. Like I said, you're a total rock star. Talk to us about this law being changed, but also just the case of Brianna Taylor in its entirety as you see it.
So Brianna Taylor's case was another horrifying iteration in what seems like a litany of deaths arising from military-style raids by police on homes. Brianna Taylor was in her apartment. She was asleep. It was the middle of the night. Police entered her home in a military style without announcing who they were, not knowing actually that the person they were supposedly entering the apartment to find was already in custody. So they're going there to find a person who's already in police custody. They go in, they don't announce themselves, according to Ms. Taylor's boyfriend, who, thinking the house was being robbed or that there was some sort of armed intruder coming in, fired a warning shot. In response, police fired many shots into the home, I believe 8 of which struck Ms. Taylor, killing her. She was herself an emergency responder. She was an EMT who worked for several local hospitals. This is not new. This is something police have been doing for years. We remember several years ago, Ayanna Jones, a 7-year-old girl, was killed in the same way when police raided her home in a militarized way. Generally, these raids, although those who might not be familiar with them could think of them as something that police only do in an emergency when there's a terrorist or an armed killer on the loose. The vast majority of these raids are actually used in drug searches and responses to other nonviolent crime. So what we're seeing here is a reaction by a city finally banning a tactic that has taken far too many innocent lives and is not being used in service of ending violent crime in any way.
Yeah, and as a public defender in Brooklyn, I've seen these no-knock warrants just kind of being used left, right, and center. And the argument is always, well, we're worried about the destruction of evidence. In my mind, we know that really isn't true, because if you have the basis to arrest, you have the information that they have those drugs inside the home, you have to basically balance the pros and the cons. The con being, okay, they flush a baggie of marijuana down a toilet, or as the law is coming out, either the officer or the occupants get injured. And I think it's pretty obvious that that balancing needs to come out to protect the sanctity of life and not worry about the flushing away of evidence. We're seeing this change a little bit, but part of my problem with this, and we're going to move on to the incident report in just a moment, everyone is saying this incident, as well as other incidents, are tragic. It's a tragedy that she died. It's a tragedy that has occurred. When there's a tragedy, you need to see mobilization of change. The change of law is good, but the question still remains, why are these officers not arrested? Now, Officer, I believe his name is Joshua Jaynes, who actually went and got the search warrant for Brianna Taylor's home, he was suspended and put on administrative leave. But is that enough? Let's take a look at that incident report and see that the fact that it's so blank and so bare, we have actually the lawyer for the family talking about how it's almost a slap in the face. Let's take a listen.
Tonight, the Taylor family attorney is calling that report an insult.
This is the 4-page incident report. 4 pages filled with basic details and numerous boxes left blank. After we saw it, we called Sam Aguiar, the Taylor family attorney.
It's a tremendous slap in the face to release something like this after 3 months that is so blatantly inaccurate. It's insulting.
The report details the time and place of the shooting. It identifies Brianna Taylor as a 26-year-old black female. We see the names of the officers, and then we see what appears to be inaccuracies, like this box where an officer checked no under forced entry, and this one identifying injuries. An officer wrote none. We know Brianna Taylor was shot 8 times and died on her apartment floor.
When you read a document like this incident report and you see blatant misrepresentations that even suggest that Brianna Taylor wasn't hurt, that's injustice, that's an insult, and that's just LMPD's way of doing things their own way. And it needs to stop, and it needs to stop now.
Now, Emily, I know that you are no stranger to inaccurate police reports, but this goes beyond that. Seeing that there was no injuries and no forced entry, and then you look at the narrative portion, it's insulting. I don't think it's just a slap in the face to Brianna Taylor's family. I think it's a slap in the face to us as citizens and people in the United States that the government can just do this and simply just say, you know what, just believe us, we're not going to write a report. What did you take from this incident report?
This is, you're right, in no way unique. And what I take from it is that it's evidence of a comfort with obfuscation and with misconduct and with dishonesty that is culturally endemic among police. As you mentioned, as a public defender, one gets these reports all the time that are not filled out, that are inaccurately filled out, that are deliberately limited so as to not fully investigate a crime, lest it create too much writing that a lawyer could find out too much from. So police are actually trained to write less. They are comfortable lying. They often find themselves protected when they do so, even under oath, by prosecutors or judges who will consistently give them more than the benefit of the doubt when it comes to inaccurate testimony. In my nearly 10 years as a public defender, I experienced multiple inaccuracies under sworn testimony coming from police. So I would ask them a question, they would lie to me under oath, and I have never seen an officer prosecuted for perjury the way an ordinary citizen like you or me would be prosecuted if we were to lie under oath. But I will note that the discovery here by the public of this shocking, blatant, like almost arrogant document is not simply limited to you and me feeling like this is a continuation of something we've been seeing as attorneys for a long time. This horror and this shock and this anger is now leaking out, as we've seen during this uprising, into the public. There was actually some really interesting polling from the Justice Collaborative Institute and Data for Progress this week that showed that for the first time, to my knowledge, a bipartisan majority of likely voters oppose no-knock rates. They think they're too dangerous. They think they're too likely to harm innocent people and children. They think they're dangerous to police too, but their concern now goes to the people that police might harm. And I think that making the public aware of the culture of confident dishonesty that is endemic in police departments is going to further fuel that fire of public outrage at what has become normalized among police.
Yeah, and I think you hit on some amazing points, because this is what the thrust of this arguments are. This is not a couple bad apples argument. This is a systemic problem. They are trained to evade and to give the minimum amount of information so that when you and I are cross-examining them, or when other attorneys are trying to get to the truth, we are stonewalled because we don't have the proper paperwork, the proper facts to investigate. And judges and prosecutors aren't looking for that, contrary to what you might see on television shows or other networks, because they are stonewalling us. And that's why in cases like this, we can't even seek justice, because we look at a report and there's nothing. So I don't know how you're asking us to find justice in this quote unquote tragedy when you're not doing anything to help find justice. We're going to take a quick break. We're going to come back and we're going to talk about the George Floyd case because one of the officers actually made bail. And we want to talk about how that bail was made and how that differs from people like Emily and I, or even you watching. We'll be back after this. Thomas Lane, the officer involved in the murder of George Floyd, has made bail. Now, he's the officer who's accused of simply holding down George Floyd's legs while Officer Chauvin had his knee forced upon his neck, and another officer on his back. Now, he's charged with aiding and abetting in murder because he was a part of this all. He made $750,000 bail, and we're finding out that most of it was from crowdfunding. Crowdfunding is great. Many of my clients get out on bail because of that. Not $750,000 bail, not on murder charges. But it begs the question, if we're all up in arms yelling that what happened to George Floyd is so horrible, how is he raising this much bail? It's got to have support somewhere. Seems a lot more than a few bad apples. But let's listen to his lawyer, Earl Gray, do a horrible job in terms of defense and trying to defend his client on CNN. Let's take a listen.
Saw the full body camera on my client, I believe that they would have a different opinion, particularly if they had any knowledge of what police procedure is and how they should proceed on a felony arrest, particularly when the individual they are arresting is under the influence of some kind of drug. He did everything that he thought he was supposed to do, and he did more than that. He went into the ambulance, and he's the one that was doing CPR. He's a man of compassion.
Emily, this is part of my issue. Everyone's trying to make this argument of he's been on the job for 4 days, he's not that experienced. I take that as somewhat of an insult to my intelligence because he's been on the job for 4 days, but he did his training. At the very least, I don't know how long they train, but they typically train for 6 months prior to. When I have new interns or new lawyers come in fresh out of law school, they're sharp on the law. They know what to do. They're sometimes educating me on how to make different arguments on motions or in cases. They should know more than anyone else what the laws are. A duty to intervene when another officer is committing a crime. So this 4-day garbage doesn't fly with me. How do you perceive this argument that, let's call him a lawyer for argument's sake, Earl Gray is making?
I will agree with you that I don't think I was ever more cautious and perfect as an attorney than I was when I was first taking on the job and trying to make sure that nothing I did caused anyone any harm. Because as an attorney, you can do a lot of harm if you do your job badly. Certainly not nearly as much harm as you can do as an armed police officer. What I just heard from Mr. Gray was actually shocking to me on many levels. One, you're right. There's something called the police academy. They do go train for this. You're also not supposed to leave your humanity at the door. When you are harming another person and they are begging for their life and saying they can't breathe, that should cause you to change your behavior and deviate from whatever you believe procedure to be in order to save a life. Another problem I have with this, though, is that it's not anywhere normal procedure to strangle someone while trying to arrest them for a counterfeit $20 bill. I'm sorry, that just doesn't make any sense. There's no allegation here that he had even, done anything threatening enough to warrant the kind of forcible arrest we're seeing. But all too often, this use of force is simply a first resort, a matter of practice. Police are in the habit of acting violently, especially towards Black and brown people, especially towards Black men. And the casualness of violence that we see police exerting in the video of what happened to George Floyd is not a one-off. It's not unique. It's happening in every state, in every town, in every jurisdiction. So if a new officer was not reacting to that in a way that saved a life, it's probably because the culture of that department and the culture that had seeped into the academy training reveal to us how violent these departments really are.
Yeah. Now, we've been talking about the prosecution of individuals who commit crimes, especially police officers, against everyday citizens. Whether you want to say, hey, they're criminals or they're not, they are still citizens and people of this country. And when one commits crime against another, they should be prosecuted. Calling it a tragedy is not enough. You've got to take that extra step. And we're also talking about the implementation of laws to better the society going forward. And I want to make this quick point right now because I think it's important. On June 12th, today's Loving Day. Today's the day that the landmark decision of Loving v. Virginia allowed people to love regardless of their race, religion, or creed. And it's laws like that that I think we need to highlight to ensure that there's an equality amongst all of us. And it's especially very personal to me because without Loving v. Virginia, I wouldn't be able to love the woman that I'm married to now. And so I think these laws need to be implemented to ensure that there is fairness, equality, and sanctity of life going forward. That bleeds into our next topic, and that being how prisoners and incarcerated people are being subjected to working. Now, if you haven't read the 13th Amendment, it's of course one of my favorites. It affords me a lot of liberties in this country. But there is an argument, and I would say a strong argument, that the 13th Amendment does, in a very narrow exception, allow for some forms of slavery. You can see it there on the screen. I'll read it out as well. Neither slavery nor involuntary servitude, except as a punishment for a crime, whereof the party shall have been duly convicted, shall exist within the United States of America, or any place to their jurisdiction. That reads to me, no slavery unless you've committed a crime. And I bring up that point because as we're seeing California over the last couple of years, burning because of wildfires, because of global warming, because of just the environment that we're seeing now, we are using convicted felons to work as firefighters, which is fine. I get it. But they're getting paid less than $5. And when they get out, they cannot use those skills to make an honest dollar and be a firefighter, which I think many of us by and large respect and need in this country. I don't care what a firefighter's background is when they break through my house and try to save me. I don't see why we can't properly give them that money they deserve. But let's take a look at a quick clip talking about this issue of not giving people their proper due just because of a criminal record.
Now, you would think any prisoner volunteering for a dangerous job like this would be in it for some big reward. But it turns out that's not the case.
Inmate firefighters get paid an average of $2 a day. When they're battling live fires, they earn an additional $1 per hour.
Though they only earn about $1 per hour to risk their lives, every day of work as an inmate firefighter counts as 2 days toward their sentence.
Wait, hold up. Inmates get 2 days off their sentence for every day they fight the fire? That's not much of a reduction. Like if I was an inmate, I'd just want to keep the fire going. Yeah. I'd just be out there like, oh no, I accidentally turned my hose to the spread fire setting again. Oh, darn. And also, I don't care if they're prisoners. Getting a few dollars a day to fight a wildfire is bullshit. Now, while the prisoners are getting basically nothing for doing a dangerous job, the state of California saves an estimated $100 million a year by using inmates to fight the fires. And what's extra messed up is that despite fighting fires year after year while in prison, many of these inmates aren't allowed to use any of that firefighting experience once they've served their time.
Despite their experience, an inmate firefighter may find it tough to land a full-time job after they complete their sentence. To become a firefighter, most departments require an EMT license, but EMT certifying boards have a pattern of denying applicants with a criminal history.
When they leave that service, they are told they will never, ever be allowed to be a firefighter.
It's a correctional facility. If I'm believing what your argument is, that these individuals committed a crime and they're going in to correct themselves and they're supposed to be coming out to do better, why not allow them to use the skills they've learned in that correctional facility so they don't return back there? Sounds like a pretty reasonable argument to me. Emily, what is your take on this issue of inmate firefighters and the lack of pay and is also not being able to use their skills outside the correctional facility?
So you're absolutely right. This is not just about firefighting. It's also about other forms of work that are available to people who are living inside prisons. You can't get a barber's license once you're out, or electrical. And there's many jobs that you learn how to do: plumbing, electrical, barbering, certain forms of specialized technical work, products assembly, many of which will not hire people with criminal records or require licensure that's not available to people with criminal records. So first of all, we have to change the licensure problem. Any job you can do while you are in a prison, you should be allowed to do when you come home. Otherwise, you're right. What is the point of all of this training? But the larger point is the slavery point. Oftentimes, the discussion on these issues lacks nuance. People say, it is slavery. It is modern day slavery. And in fact, that exception that you noted in the 13th Amendment arose from a desire to re-enslave Black people in the southern states. They developed entire bodies of law designed to criminalize ordinary conduct for Black men so that they could incarcerate them and lease them back to slaveholding plantations. So this entire exception arises not as an analogy to slavery, like very directly from America's history of slavery. But looking at the modern day iteration that we have here, too often the discussion is, it's terrible, people are enslaved, people living in prisons shouldn't be allowed to be firefighters. When in fact, sometimes the boredom is the punishment. And you want people who are living in prison to have the option of taking a meaningful job, learning a new skill, doing something with their time so that they're not sitting in a room staring at a wall. The problem is the pay. If the state of California is saving $100 million, they should be paying people for their labor. That is good not only for the ethics of us as a nation, but it's also good in terms of rehabilitation. When you pay people for their labor, when you value their work, when you give someone not a fake job, but a real job where they can actually earn money, save up a nest egg, you're talking about being able to send a card to their kid at Christmas. You're talking about being able to purchase necessary items from the commissary. You're talking about being able to afford the exorbitantly priced phone calls that keep a person connected. Sorry.
I'm so sorry to cut you off, Emily. I wish we could keep going, but Vince, we're coming to you in the next half hour. What do you got for us coming up?
So we're going to be talking about the Brianna Taylor case. We're also going to be talking about the no-knock warrants and what the Minneapolis Police Department is doing to make further changes within the union and their contract negotiations.
Yeah. So Vince is going to pick up where we left off. Emily, I hope we get to have you back here. I'm sorry we have such a short time, but we're going to continue to talk about this and other issues next week. Happy Loving Day, everyone. See you on Monday.